the faculty lead of the governance program. It is my distinct pleasure to welcome you to this event, which, as you know from the title, is an event organized in anticipation of a particular ruling of the European Court of Human Rights in Strasbourg on the Molla Sali case. We have a very distinguished lineup of speakers, including our first speaker, who is also the applicant on the case. So we also have some insider information here to discuss and share. And I actually expect to have a lively debate and discussion on these very timely issues. So I will not take any more time. I will introduce, so there's 4 speakers, as you see, and I will introduce them one by one. So our first speaker is Konstantinos Tsitselikis. He's professor at the Department of Balkan, Slavic, and Oriental Studies at the University of Macedonia in Thessaloniki. For those of you who have read or worked on the issue of Muslims in Greece, he's a household name. I would just point to his 2012 book, All the New Islam in Greece, From Traditional Minorities to Immigrant Newcomers. But again, I will not take more time, and I will give the floor to Konstantinos, so please join and welcome him with me. Can he close the laptop? No. You can leave it ajar though. How about this? No.
No, it's not very convenient.
Why don't you
All
put
right.
it on the chair?
Anyway, so thank you very much for the invitation and the pleasure to be together here for this discussion, presentation about Islamic law, Sharia law in Greece, but not only in Greece because it's a very topical issue, but Sharia in Europe. This will be the context. But of course, to explain a little bit first the facts and the configuration of the position of Sharia law in Greece, because it's a very peculiar situation where we have state courts, state Sharia courts in Greece. So why? So I have to explain this a little bit because it's a kind of peculiar situation in Europe. So a Muslim Turkish minority in Greece is a historical minority, so there is a history behind this. From the beginning of the establishment of the Greek state, and then a very traumatic and very important event goes after the Turkish-Greek War of 1919, is the end of this. So the two states decided to exchange minorities, seen as the enemy element from within. So all Muslims from Greece had to move to Turkey, and all Greek Orthodox to move from Turkey to Greece. Okay. So this is another important issue. Of course, we cannot have the time to discuss about this, but something very important. So what happened with this? They want to eliminate the other, but they kept someone as a minority, so as an exemption to the population exchange. For those who remained as a minority, so the Muslims of Thrace in Greece, there was a special protection system. So the Treaty of Lausanne of 1923 set up a protection we call positive measures now in favor of the Muslims. So special rights were granted on the ground of religion. This is important to understand the whole picture. So among other specific rights like education, special education in Turkish, for instance, there was a Mufti who remained in Greece as a judge. This is a Balkan characteristic. Only in the Balkans, in other countries like Bulgaria, Yugoslavia at that time, the Mufti became judge for some specific matters. Family law and inheritance law. And still for some specific cases of this. I'm not going to go into details because I don't have the time. But let's say divorce is the most important issue that Sharia law is applicable through the Sharia court, and the court is one judge, the Mufti. Okay, so we have 3 Muftis, 3 courts in Thrace. So they are not only recognized by the state, but they are state courts. Okay, so this is important to understand why this survived. This is another question, why this court survived through time. Because in the 20s, 30s, in the pre-war period, of course, there is a specific picture of the political situation in the Balkan countries, but after the war, similar courts closed down in Romania, Bulgaria, Yugoslavia, because of course of the communist governments, or they didn't want to tolerate anymore this specific jurisdiction. So only Greece, only in Greece survived these courts. The question again is why? Because there was an antagonism and a controversy between Greece and Turkey. I don't have the time to go into this. If you have any question to understand why Greece kept them alive up to date. So the main legal problem that remains is the compatibility between Sharia law and human rights fundamental principles. And the most important, to make it short, are 2. Equality of sexes and the interest of the child, as we call it. So, because Sharia law, if a case is adjudicated according to Sharia law, men take more or have more rights than women. Okay, this simple. In case of custody for children, father has some more rights regarding the mother. Okay, so this is a big picture. In inheritance, of course, is again that the male takes the double lot from the female. So this is a big picture of incompatibility between the 2 systems. The political question behind this is how and why this system is kept. I'm not going to go into details because, again, the answer belongs to bilateral relations between Greece and Turkey. So how law, this is our important issue here, tolerated this non-compliance with some obvious problems between the 2. Okay, so after the 60s, after the 70s, the 80s, the 90s, where human rights were more enhanced in the European family and through the European Convention of Human Rights applicability, because we have to take into account that by the time the European Convention of Human Rights, through the court judgments of Strasbourg, was creating common denominator, as we call it, as regards human rights among the whole family of 46 different countries. So here we have a topical issue of non-compliance. For some it was obvious. For some would be a change would be needed. We have a case of the French Mayotte that already 10 years ago they had Sharia law applicable, and then there was a referendum, and through a referendum Sharia courts were abolished. Okay, so it's the only case in Europe now, the 3 courts in Greece. And then the case appears. There was a couple of Muslims in Greece. I'm not the applicant, by the way. I'm the representative of the applicant.
But the court refers to you as the applicant.
Okay. Yeah, exactly. So there was a couple drafts a public will according to the Greek civil law, leaving all properties to his wife. There was no children in the family. Okay, so there was a clear case. It's not mine, this, but it's absent. So the male dies, and then there's the process of implementing the will, the public will. Registration of the properties, paying taxes, etc. etc. So if later, the sisters of the deceased claim that Sharia should be applicable and that the public will is null and void. The first instance court says no, he's a Greek citizen anyway. Even non-Greek citizens have the right to apply before a civil court, to implement what the civil code says about inheritance and to have a public will. The sisters appealed against this decision, and the Court of Appeals of Thrace says the same, not okay, there's no ground to declare the will as null and void. And then the third level of jurisdiction, the Court of Cassation, says that no, because the deceased was a Muslim, so Sharia law has to be applicable by default to him. So there's no way he has an option to go to the civil court, so Sharia law has to go to apply. And if Sharia law applies, 1/4 of the properties remain to Mrs. Molla Sali, and the rest of it, the 3/4, go to the two sisters, because they are the sisters of the male deceased. Okay. And then we took, with a colleague of mine, we took the case to the Court of Strasbourg. So one interesting question, why not earlier any other woman didn't challenge a similar judgment? Because then we have to approach in a sociological way the whole situation, because women are the weak part of the society, and most of the women cannot undertake such an endeavor. So there's a oppression. There's a political answer also, because the Greek authorities also don't want to change their system, because to keep the balance between Greece and Turkey in the name of the minority rights. No. Let's see now what the Court of Cassation said, because it's a kind of, it sounds a bit peculiar that the Court of Cassation says that if you are a Muslim, Sharia law is mandatorily applicable to you. So the Court of Cassation said that because of the Treaty of Lausanne and the specific protection framework, all Muslims enjoy specific rights. One of these is the Sharia law applicable by the Sharia court, and in the name of security, of law and national security, we have to keep the system. It's for the good of the minority. So, okay, we can call it paternalistic, we can call it to approach it in different manners, but legally speaking, the fundamental issue here is the right to opt for one or the other system. The second question would be to make a check between the substance of the rights, so not to be discriminated, if we compare the two systems also. To make clear the whole system is that all decisions taken by the Mufti in such matters, they have to be ratified by the Greek court. So according to the law of 1990, the Greek court, the first instance court, has to apply a constitutional control and to check if the content of the decision according to Sharia law complies with the principles set by the Constitution, the Greek Constitution, and the European Convention of Human Rights. So what happens in practice is, in all cases, 100%, the local courts avoid such a control. Because we can imagine that if they have applied this control, they would have declared that the Mufti decisions are violating some fundamental human rights principles. So you see here there's a kind of bypassing the legal controls in order to satisfy a political idea or goal to keep the balance and not touch the minority protection system. So, which were the claims before the Court of Strasbourg? Violation of Article 6, that means denial of justice, because the Court of Cassation said, no, I'm not going to judge me as a court, the case, and who has absolute jurisdiction is the Mufti. So that means that what the Article 20 of the Greek Constitution says, that everyone in Greece has the right to access a court, and specifically the civil courts, the civil disputes have to be judged by a civil court, is bypassed already. This is problematic. So violating Article 6 of the Convention. Plus Article 14, that's discrimination. So it's a discriminatory policy applied by the court. So because they are Muslims, they cannot have access to the civil code. So this is one cluster of the claims. The second one is Article 1 of the first protocol. So right to property. Plus Article 14 again, discrimination. Why? Because the applicant is going to lose 3/4 of the properties in application of this decision by the Court of Cassation. Why discrimination? Because if she were Christian or non-Muslim anyway, the Sharia code wouldn't be applicable. If she were male, so we have double discrimination. If she were male, the lots were different in favor of, they wouldn't be like in that case, to lose 3/4 of the properties. So here we have the principle of non-interference. So how the state, through a high court, interferences in the balances and the content of fundamental human rights as described by Article 6 and 1 of the first protocol. And access to the court is a basic thing here. The right and the freedom to opt for one or the other jurisdiction. In case we find a way to tolerate, so to have a kind of two different systems, say the human rights civil law and the Sharia law, we have to find a kind of compliance for both. Here, there was no freedom to try to have access to the other system. So this obligation violates, confronts the freedom of option. So this is the essence of legal pluralism. Of course, the second question I mentioned in the beginning, the content of rights are not challenged by this case, unless the court goes into deeper waters. It doesn't stay only to the claims as denial of justice and property, but goes to the compliance of Sharia law with human rights in general. So this is another big challenge for the court that works, and we expect the judgment in December, most probably. Nobody knows, but it's a year after the hearing, so expect that we'll have it. So I think these were the most important things about the case. And the last thing you should know, and I have to tell you, is that the Greek government anticipated an amendment to the Greek law in order to comply with the expected judgment. Of course, nobody knows the content of the judgment, but we expect that a violation, at least one, will be found by the court. So what did the government? To change the law, to amend the law in order to make it explicit that the Muslims of Thrace would have the option, so to be free to have the option for one or the other system. This I think is very important. So we have the first legal effect already by the law. So what happened, and this is something new, I don't know if you know it, it happened yesterday, 2 days ago. In January, the law passed, just a month after the hearing. And the law says, first of all, that the public will, it says two things. The public will now is allowed to Muslims, anyway will be allowed, but now is explicitly said that public will is drafted by Muslims, so according to the civil law. And the second is that jurisdiction of the Mufti exists, is not abolished, but both litigants have to agree in order to take a case before the Mufti. So it says that by default, the Greek court is competent to adjudicate the case. So only if two of them want to submit the case before the court of Mufti, they can do it. And says, because there is no procedural code, let's say, or law so far, in the past 90 years, there was no procedural norms. It was a kind of chaotic system. Now we have to have, through a presidential decree, the procedures of the court. However, this was perfect, okay. No objection to this, was a step ahead, let's say. But it linked the law, it linked the applicability, the implementation of the law with the drafting of a presidential decree. So we have to wait until the presidential decree is published in order to have the free option as a legal norm. And the time passed, 1 month, 2 months, 3 months. Now we're by the end of the year, nothing happened. And a lot of people, the comment was, okay, they want to undermine the law to keep the previous situation, so we'll have election in a few months, nothing will happen, and the system will collapse again. And that happened 2 days ago. There was a new amendment disconnecting the presidential decree from the law. So the law is applicable now. So from today, it's optional to choose the civil court or the Mufti court. Okay, so this is the big, I gave you the big picture. I stop here, I think I'm okay with the time. Thank you very much for your attention, and of course, I will be happy to answer your questions.
Thank you, Konstantinos. See, I'm not the only one. Of course, Konstantinos was the applicant on the side of the widow, not the. I'm a strong supporter of the sisters, but if we will have time, I'll say a bit about that later. So let me just introduce the second speaker. The second speaker is Yüksel Sezgin. He's associate professor of political science at the Maxwell School of Citizenship and Public Affairs at Syracuse University. He has extensively worked on issues of Sharia and civil courts in a number of jurisdictions, including Greece. So I'm just going to point to one publication of his, Human Rights Under State-Enforced Religious Family Laws in Israel, Egypt, and India. So Greece is not in the list, but he has looked at Greece in other works of his. So even from the title of the book, you understand why we have him here. So we look forward to hearing you. So please join me in welcome.
Vahab.
Can we dim the lights in the front? Dim the lights in the front.
Hello, good afternoon all. Let me start by thanking the organizers. It's a great pleasure to be in this very beautiful building and center today. I'm also very pleased and honored to be in company of such distinguished scholars. And most importantly, I am particularly honored by sharing the panel with Professor Tsitselikis. I always learn a lot from him whenever I read his work on Greece. Also, whenever I talk to him, also I continue to learn today. So I am a comparative political scientist and a lawyer. So what I would like to do today, just very briefly describe, to follow up on Professor Tsitselikis' presentation, just follow up what's happening in Greece and place the Greek issue on a global perspective and speculate on the prospects of external and internal reform within the Mufti system in Greece. So, state enforcement of religion-based family laws, they violate in particular 4 groups of rights. Number 1, it violates equality before the law. It violates freedom of religion. It violates family-based and as well as marital rights. And it also violates some of the procedural rights such as due process and fair trial. So with this background, we can most strongly expect that in a few months, the European Court of Human Rights will find violation in the pending case. It will most likely say the Greek government has violated the applicant's right to a fair trial, her right to property, and has also discriminated against the applicant on the basis of gender and religion. So when that judgment becomes public, the Greek government will have 5 possible responses to choose from. It could basically say, I disregard the judgment of the Strasbourg court, I will carry on the business as usual. No response whatsoever. That's number 1 option. Option 2, it could abolish Muslim family law and Mufti system entirely. It could say very simply, like Turkey did in 1926, or Greece did in respect to Jewish citizens of Greece in 1946, that from now on, all Muslims in Western Thrace are subject to Greek civil court and law. That's another option. Number 3, it could separate religious functions and adjudicative functions of the Mufti's office. It could allow the minority to elect its Muftis, who will have no official capacity or no office whatsoever, in line with the previous Strasbourg court rulings. It could also establish, like many other non-Muslim countries, Sharia courts. It could just appoint qadis to apply Sharia law in Sharia courts in Western Thrace, like that's the case in Israel or a few other non-Muslim countries. Or it could apply, it could just eliminate the office of the Mufti, it could apply the Islamic Muslim family law within civil courts, like in India, where in India you have the secularly trained judges applying Islamic Muslim personal law in civil courts. That's also another option. And number 5, option 5 is partial overhaul of the current system. So Greek government, as previous speaker has mentioned, passed a new law, law number 4511 in 2018. They also issued a draft presidential decree on September 2018. So in the light of these new legislative developments, it looks like the Greek government has already opted for the option 5, meaning just a limited overhaul of the system in order to remove the concern that led to the pending case before the European Court of Human Rights in the first place. So what I'm going to do today, I will very briefly look at the law number 4511 as well as the recent presidential draft decree and provide a critique of those 2 instruments and try to place the Greek system in a global perspective, as I mentioned earlier, and also speculate very briefly about the prospects of reform from within and from outside as far as the Greek Mufti system is concerned. So what happened in January 2018, Greek government had passed a new law that basically amended the previous law number 1920 from 1991 It added a sub-article, Article 5.4. It briefly allows Muslims to choose between civil courts and Mufti's jurisdiction. So if they want to invoke Mufti's jurisdiction, both parties have to agree in writing to the jurisdiction of the Mufti. Otherwise, the primarily jurisdiction will belong to civil courts and the Greek civil law. And as Professor mentioned previously, Article 5.4, the law said will come into force when a new presidential decree is issued that would regulate the issues of procedure in Mufti jurisdiction or Mufti tribunals. And I was not aware of the recent development just occurred 2 days ago. So as you see, I continue to learn. So this is what the law very briefly said from January 2018. A new decree had been issued on September 2018, just a few weeks ago, and it has about 28 articles. I will very briefly tell you what these rules concern. Subject to Article 2 and 3 deals with the issue of subject matter jurisdiction and territorial jurisdiction of the Mufti. What issues such as personal status, family issues will be subject to jurisdiction of the Mufti. It will only be applicable in Western Thrace. So we have to understand Sharia is not applicable in the entire Greek territory, but only in a specific region. Those who are not familiar with the Greek map, this is the area just adjacent to Turkey, bordering, and the area has primarily Muslim citizens, and many of them do speak Turkish as their native language. Article 5 says, I think this is very important, as I will highlight in a second, it says every party appearing before a Mufti tribunal has to be represented by a lawyer, and those who cannot afford a lawyer will be provided pro bono lawyer. Article 6 talks about, Article 4 talks about minimum age of marriage. It says minimum age of marriage should be 18, but Mufti can also allow underage marriages with the approval of the guardians. Article 6 talks about the written proceedings. It says proceedings before the Mufti must be written. Mufti judgments have to be published. Article 10 says proceedings must be conducted in Greek language. Article 11 says Mufti judgments are issued in Ottoman and Greek language. Article 13 talks about the constitutional review, and Article 14 through 22 mostly deals with the administrative issues, and also talks about the fact that from now on, every Mufti tribunal should have one legal advisor who has at least 3 years of minimum legal training from a nationally recognized legal institution in Greece. So, since the issue made the headlines across Europe, since the issue came before the European Court of Human Rights was it 2014 you first filed the case, right? So since 2014 and since 2017, since the Grand Chamber hearing, it made a lot of headlines. But as someone who has been following these news, I see that there's a lot of misinformation about the Greek case, how unique Greece is. Yes, it is true Greece is unique in the context that it's only European country where there is Muslim family law, as people call Sharia. But at the same time, we have to understand the fact that there are 53 countries in the world which formally integrate Muslim family law into their legal system. 18 of those countries are non-Muslim majority countries, just like Greece. And 5 of these non-Muslim majority countries apply Muslim family law or Sharia within their civil courts, just like an Indian case. Tanzania, Myanmar, India, Ghana, Uganda, they apply Sharia within their civil law system. The other 12, they do apply them in so-called Qadi or Sharia courts. And Greece is the only country in the entire globe where muftis apply Sharia for the reasons that Professor Tsitselikis has just indicated. The Muslim family law, the substantive law the mufti applies is not codified. Rules of procedure, rules of evidence, etc. he applies are not codified either. And although there's a constitutional review, in practice it's non-existent. Basically, every mufti decision has to go through a review by the local court of first instance before it can be declared enforceable, and the court has to review whether mufti decision is in compliance with the Greek Constitution and the European Convention on Human Rights. But in practice, it's just non-existent. Again, I'll tell you how we can make it, or Greek government can make it more practical. So in terms of the checks placed upon the Mufti's powers to make it Mufti rulings more compliant with basic human rights and the rule of law, Greek Mufti system, in comparison to other 53 countries, law ranks very low. I would like to share this with you. And this is based on an index. It's called Index of Rights-Based Accommodation of Muslim Family Law. It basically shows the extent to which Muslim laws are complying with human rights and rule of law in different countries in the world. So red represents non-Muslim majority countries. Green represents Muslim countries. The yellow right in the middle, I don't know if this has, right, that exactly, is Greek system, Greek Mufti system. This data is based on 2016. Higher the score, more compliant that country's family law system, Muslim family law system, with human rights and rule of law. So lowest scoring country is Saudi Arabia. It has about 6%. Highest scoring country is Mali, which has about 70+%. And Greece has about 36%, right in the middle. I will also show this very similar chart at the end of the presentation, where the Greek system will be, globally speaking, if the current system is put in place, the new law and the new presidential decree. So, long story short, the Greek Mufti system has long needed a comprehensive transformation. It was non-compliant with the Greek constitution, with the European Convention. When you compare it to many other countries, it really had very serious problems. It needed a comprehensive repair, but the Greek government has only attempted for a quick fix, if you like. Despite the shortcomings of the new law, as well as the new presidential decree, let me just point out what aspects of these two legislative instruments can be considered as improvements on the existing system. Number one, again, it provides a very broad exit option. If you may be a Muslim from Thrace, if you marry in front of Mufti according to Islamic law, you can still opt out of Mufti's jurisdiction according to the new law, and you can just go to civil courts to divorce. For instance, that kind of broad exit option, concurrent availability of civil and Islamic jurisdiction is pretty new. And again, when you compare it to many other countries, it's very flexible and liberal. And number two, it really defines the jurisdiction of the Mufti. It has been very ambiguous in the Greek decisions of the Greek courts, if you like. Again, they define the subject matter jurisdiction very well, territorial jurisdiction very well. It existed previously, but it's good to reinforce it. It says the proceeding before the Mufti has to be written. I think that's a very important development. Mufti's decisions have to be published. It's very important rule of law concern in terms of predictability to make this system more transparent. Mufti has to regularly publish his decisions. This is very important. Appointment of legal advisors, also very important. It says not every Mufti tribunal will have a secularly trained legal advisor. This is a new improvement. It says every person appearing before Mufti jurisdiction will have a mandatorily available legal representation, legal counsel, lawyer. And if you don't have one, again, if you don't have the financial means, the government may provide pro bono one for you. Of course, the constitutional review, you have to understand the type of constitutional review the Greek law requires. It's ex ante, meaning that Mufti decisions cannot, technically, theoretically speaking, cannot become enforceable unless it goes through the constitutional review first. Of course, as I said, in practice, it's not applicable. It really doesn't exist. But theoretically speaking, Greece is the only country where you have ex ante review of Sharia rulings in the entire globe. Normally, in many other countries, review is ex post. So the burden is on the parties that you have to prove that the court, Sharia court, has violated your fundamental rights or it acted ultra vires. So this is a very important aspect of the Greek system. Unfortunately, it is not being properly utilized. So what are the negative aspects of shortcomings of these two legislative instruments? Number one, it said previously, based on September 2018, it said proceedings before Mufti have to be conducted in Greek language. I mean, I'm just learning that with Professor Tsitselikis' intervention, the Greek government struck it down, but it was very negative in the sense that the native language of the most of the Muslims in Thrace is Muslim, Turkish, and Mufti speaks Turkish. It was unfortunate that it required people to conduct this in Greek language. That was negative. So it says decisions of the Mufti have to be published in Ottoman and Greek. It has to be published in Greek because this is Mufti tribunals are part of the Greek government and they have to be reviewed by the civil courts. But I don't understand necessarily why they have to be published in Ottoman. Ottoman is an archaic language, and most people who appear before the Mufti's court do not even understand. I have seen many cases with my own eyes before the Mufti courts. I have spoken to many members of the minority. They cannot even understand the basic judgment of the Mufti. It's a very serious rule of law concern. It has to be published or written in modern Turkish. That's the language of the minority. So the decree also talks about the age of minimum marriage. I think it's a wrong place to really raise the issue. Normally, you should not be really trying to deal with the issue of age of marriage in a procedural regulation. It should be part of substantive codification of Muslim personal status law. You should set up a committee which will have members, Muslim members of the Greek Parliament. It will have Islamic scholars. It will have NGOs, civil society, women's rights activists, and they will prepare a code and submit to the Greek government. It should deal with the issue of talaq, unilateral extrajudicial divorce of Muslim husband. That's a very important concern. It has to deal with the issue of polygyny as well as minimum age marriages. So that's a very serious problem. There is no mention of female representation in the new law. So the law could basically say some of these legal advisors to be appointed to the Mufti court should be female. What about female muftis? The issue of female, as far as to best of my knowledge, there is no prohibition within Islamic law that bans women from becoming mufti. There is that discussion taking place in Southeast Asia, particularly in Malaysia. And also if you look at Sharia courts in Malaysia, in Philippines, in Indonesia, in West Bank, in Israel proper, where you have female qadiyah. So women can become female qadis, right? So why there is no mention of that? Most recently, April 2017, Israeli government started appointing Muslim women as Sharia court judges. It's a very important requirement that we are still missing from the Greek system. Qualification of muftis. Muftis are educated outside of the country. They have degrees from Arab countries in Islamic law, in Islamic literature, great, but they have no training in modern Greek law. They have no training in European law, no training in constitutional law. That has to be also required of the future muftis. There is still no direct appeal to mufti judgments. Mufti is the only judge in the entire continent of Europe whose decisions cannot be directly appealed to. You need to establish maybe a second level of court, a Sharia court of appeals, where you can appeal mufti's rulings and maybe do a more proper review of mufti decisions. Again, I don't have much time to talk about the ex-ante review, but the system, as I said, is inefficient. How can you make it more efficient? Number one, in the review process, you have to recruit experts from the minority to the civil courts. You have to sensitize, you have to train civil court judges in the region in Islamic law. You have to recruit Muslim judges, judges from the minority to the Greek courts. To the best of my knowledge, there is not one single non-Muslim, non-Christian judge in the entire Greek system. Even in Israel, there are Muslim judges in the civil courts. So civil courts are very much inaccessible in that regard because these people are not familiar with the cultural aspects of the Islamic law in the region. So you need to have civil judges from the community. And also, most importantly, the Court of Cassation has to change its essentialist, orientalist discourse as far as Islamic law and Muslims in the region is concerned. All right, so despite these very important shortcomings, If the ex-ante constitutional review system can be properly utilized along the lines I have just indicated, if the exit option, meaning the concurrent availability of civil and mufti courts to the Muslim minority in the Thrace, can be utilized. So what are the minimum conditions for people to utilize it? Number one, you have to raise the awareness within the Muslim community in Thrace of the existing concurrent jurisdiction. Women, underserved communities, and people should know that there are civil courts which are available to them. You have to have civil society organizations setting up legal clinics, making civil courts more accessible to the minority members. You have to have pro bono translation. Again, this is a very important issue within the Greek community, the Greek Muslim community, that some people are not, many people are not very conversant in the Greek language. They cannot read, write. So you have to really make pro bono translation available. And as I said earlier, you have to have judges from minority on civil court benches so that when Muslim minority members go to court, they will see that, oh, okay, these are also my courts. They are familiar, right? So there are people who understand their culture. There are people who speak their languages. And if the provision concerning mandatory legal representation is properly enforced, I believe that Greek Mufti System will make an important improvement on the current status. Again, going back to that earlier index, that shows that the degree to which the Greek system is complying with human rights and rule of law. Greece, according to 2016, also 2018 data, is right in the middle, that yellow one. But if you look at Greece in 2019, it will move right up to here. So this is still not perfect, but based on the current legislation, the new proposed decree or presidential decree, I think this will make a very important improvement on the current system. What are the prospects of internal reform? We have to understand, or we have to acknowledge the following fact. Non-Muslim majority governments cannot easily make changes in Muslim family law. Any change which comes from within will have a much higher chance of acceptance by the community. Any change has to come from within, by the religious authorities and by the religious courts. So what is the prospect of change? I believe, at least based on my own comparative research, I didn't have a chance to mention this, but I'm currently writing a book in which I am placing Greek system in a comparative perspective, along with India, Ghana, and Israel. So when we look at the Greek case in comparative terms, I believe there is a good chance for internal reform within the Mufti system. If higher courts, the Court of Cassation, and even the lower courts in the region, if they can exert top-down pressure on the Mufti, that they have to, Mufti's decisions have to comply with the Constitution and the European Convention. Greece is a constitutional democracy. If you are a part of this nation, if you are part of this broader legal system, your decisions have to comply with the rulings and the principles of the Constitution. Number two, if Muslim litigants can utilize concurrent jurisdictions, if they are freely able to go and choose between civil courts and Islamic courts, Mufti courts, I think this will also bring about some sort of horizontal pressure on the Mufti courts. Because Muftis will realize if they don't want to lose their clients, if they don't want to lose their jurisdiction, they will need to adapt. And thirdly, I think this is still not quite there in the region, but if civil society and particular women's rights organizations are mobilizing and putting top-down pressure on the Mufti that they have to change, they have to adapt to the changing, modernizing conditions in the region, then it will create enough pressure on the Muftis to undertake internal reform. What if they don't? The fact is that if they don't spearhead an internal reform process and revival, they will become soon obsolete. Exactly, they will become obsolete and no from now on people no longer will go and resort to their jurisdiction. Thank you for your attention. I'll be happy to take any questions. Thank you.
Thank you, Yüksel. So we are now somehow going back. So two speakers have offered to offer remarks on these two framing of the issue. And Marie-Bénédicte Dembourg will actually take us somehow back to the European Court of Human Rights from this comparative overview by Yüksel. Marie-Bénédicte Dembourg is Professor of Law and Anthropology at the University of Brighton. And again, I'm just going to mention also for her one publication that probably also speaks to our discussion here, which is When Humans Become Migrants, a study of the European Court of Human Rights with an inter-American counterpoint. So please, again, join me in welcoming Marie-Bénédicte.
Thank you for this introduction, and I suppose I have to say thank you for inviting me. And I think it might be the first time that I will open a speech by saying, actually, I don't want to say that I am so grateful to be here and that it's a pleasure and this and that. And the reason for that is that actually I find myself being quite uncomfortable. And part of the uncomfort is that I actually don't really know about the problem that we are talking about. So that doesn't put me in a very good position, does it? And at the same time, even though I do not understand it, I kind of have this perception that I probably have a rather different perspective. And if I try to put this perspective in just one sentence, it's that, human rights are easy, we know what they are. The European Court of Human Rights is a beacon of progress, and the Sharia is taking us backwards. And and I'm sure this is not quite what the speakers want to say, but nonetheless, there could be a feeling that it's part of what they are saying. And if this was the message, then it's a message which leaves me uncomfortable. Now, you've heard my training is in anthropology. And what strikes me when I looked at the case is that the facts of the case, in a sense, are the classical. In French, I come from Belgium, French-speaking Belgium, but it's la tarte à la crème. It's the problem that you will always have when you talk about a clash. So it's a clash of the rights of women. It's very clear that women are being oppressed here. They don't get their share. And on the other hand, you have a culture or a religion which is lagging behind. I mean, my PhD was on colonialism on the Belgian Congo, and that was already the judicial issues which were going to come up. And in a sense, what leaves me uncomfortable is not the rights of women. So, I'm very much a feminist, like I hope many of us in the room are. But it's the fact that then there is a possibility that these very, very difficult issues can be retaken in a way which then legitimizes and makes opaque other things which are going on in the political process. So if I take the Belgian Congo, of course, these cases then did show how much these poor natives really needed the Belgians to rescue them and to come and colonize them, because through colonialism they were going to gain so much, and that was a rosy future. And so we know that that's not the history which has happened. And this is not to try to justify what's going on. It's just to say, as an anthropologist, I am acutely aware of how, social life is utterly complicated. It is so difficult. And it also struck me, as I was trying to put 2 or 3 thoughts for these remarks, is that, of course, inheritance, we are all going to die. That is one certain thing. We're not going to escape from that. So we are all going to die. Most of us who are lucky, we are going to leave things behind us. And these things need to go somewhere after our death. And of course, let's leave aside the problem that we're talking about today, and let's take, if you are not from that region, it might be easier, but let's take in a different context where we're not talking about minorities, we're not talking about Islam, but we're just talking of, my culture, if you like, and let's think of how messy I think we all know inheritance cases which have become so full of, I think because it also touches on death, it really brings up feelings even more. And then, if there are material interest and political interest and all the rest of it, it gets, it's not simple. So it is really difficult to, and in a sense, also the other thing is that, of course, there is no right solution. There might be legal norms which are being given, and there are some things you can do and some things you cannot do. But in many cases, it will become ugly, and it will become emotionally full of anger, and also it will turn into very, very big disputes for material interest. And so I don't know anything about this particular case, and I don't know, what happened with, what was the situation, how wealthy was the person who died, and what happened with the widow, and why the sisters kind of came up afterwards. In a region which, for the few things I know about it, I know that a lot of people there are actually very poor, and they've been left behind, and that is one of the problems in the region, is that they completely, they've been, and you were saying that in a sense they are potentially become a pawn in the relationship between Greece and Turkey. So it is very, very, certainly I would say, I don't know much about it, but I know it is sensitive. So it's a sensitive thing, and in a sense my discomfort then comes from the fact that we are going to have a judgment of the European Court of Human Rights, and we can, everybody knows there will be violation after violation after violation being declared. And of course I have no problem with that as such. Because overall, yes, of course, I come from a culture where I expect that when my husband dies, well, the thing we've built together is going to come to me. I don't expect it to go to his sisters or brothers or nephews or nieces. So in that sense, this really goes with my own. With my own expectation and with what I am used by. But I am known, so in that sense, yes, we need to go for some norms and some rules, and if you go with complete legal pluralism, you have a problem, and even if you agree that there will be different possibilities and different choices, you put limits to it. This is the role of the law. So I have no problem with all these things. I am nonetheless worried about what the European Court of Human Rights is going to come up in its judgment. And part of the reason that I'm saying that is that the European Court of Human Rights does not have a particularly good record at treating Islam in general with sensitivity. And so, in a sense, that is going to be, in a sense, a godsend for the European Court of Human Rights to just being able to go there and, in a sense, not give enough respect to what needs to be respected. And so that is, in a sense, my worry, which of course has nothing to do with the legal applicant. It's nothing. This is the job of the judges, or it should be the job of the judges. And I was reminded, I don't know how many of you have come across Albi Sachs, who was a judge at the Constitutional Court of South Africa. He was certainly, he's white, but he was part of the ANC. And after the apartheid regime fell through, he became a judge at the Constitutional Court. And he has written this absolutely wonderful book for any of you who are lawyers here, whom I would recommend, which is called The Alchemy of Law, and anyone on Google, please find the exact title for me. But in this book, where he writes in a very non-judge-like way, very much as a human being, telling about his experiences, and he says, when I write a judgment, and even when I have decided where the law stands, and there is going to be a winner, and in a sense there is going to be a loser, I really try to find the words which make it possible for me, in a sense, to reach the person who, in the case, is going to lose. And also, in a sense, to preserve their dignity and to understand their perspective and to try to think how my words are going to resonate with them. And I found that absolutely amazing as a perspective. To have, and I think that the chapter I'm thinking about, but again, I would have needed to check, and I did say I will only give remarks on the cuff. I cannot prepare a paper, but I think that the judgment he's particularly thinking about is a judgment where he defends gay rights. And in certain parts of South Africa, of course, that is going to be a very difficult message to come across. And he says, I really have to take everybody on board. And I don't think the European Court of Human Rights is really doing that. And one can understand why the court does not manage to do it. There are technical reasons, you could say. 47 judges coming from different traditions. They come together. They in a sense, instead of trying to bring up the complexity and all the different angles, they go for the lowest common denominator where they can agree. So that doesn't give them much ground to be able to bring nuances. They also use the technique of the copy and paste. So they take something from another judgment, they put it somewhere else. Again, that's not going to be very useful. And then I think, of course, I only have Albi Sachs' word for how good the Constitutional Court would have been. I also have to acknowledge I'm not an expert on this, so I don't know how successful it was. But there was certainly this wish on his part. And I think that the Constitutional Court, having been put forward at a time when there is a break from the past, that obviously the Constitutional Court in South Africa is being put together so that hopefully, we can go towards a future where the equality of human beings is respected. In the European Court of Human Rights, when the European Court starts, it's a very different context. You could say, well, no, I mean, after all, it's brought after World War II, so it's the same kind of context. I would say it is not really, because there is not the soul searching in Europe that there would have been in South Africa. Overall, in Europe, it was, well, we've had a problem. We've had a very, very big problem. Some abominable things have happened. We cannot allow them to happen again. But it's regarded as an accident, and it's regarded as, you know, not everybody was guilty within that. You know, the British, they fought against what was going on, so they don't have much to in fact, they were the goodies in that. And so you have different positions, which means that by the end of it, when the European Court of Human Rights comes into being, what they really want is, well, yes, let's not have World War III, let's avoid what has happened, but also, very importantly, let's check communism. Let's make sure that these parties who are doing far too well in Italy and in France don't get too much power. This is not the world we want. And so, in a sense, there are a lot of conservative forces in Europe and the European Court of Human Rights right from the start. And you know, where I begin to be more comfortable and more in my area of expertise is, and if you want to ask me questions about that, I would love it, because at least I will be able to answer. Mm-hmm. But it's in the European Convention on Human Rights, you know, there is nothing about the colonial subject, even though you still have 4 big colonial powers at the time. Decolonization is not yet thought about. Well, the colonial subjects, they're not going to be those who have human rights under the ECtHR, nor the migrants, nor the refugees, and so you know, then the ECtHR case law develops with a lack of sensitivity for these populations. And I think we have ended up with judgments which are really damning in a very categorical way about Islam. And I think that really this is not something we should get from the European Court of Human Rights. It's not good for anybody. And in a sense, it goes, to me, against the ethos of human rights. Thank you. The strange alchemy of life and law. Thank you.
So just as Marie-Benedicte recommended Alvisac's book, I will actually recommend her book. If you are interested in that particular reading of the jurisprudence of the European Court of Human Rights, and of course she has more time there in writing than here on the letter. I just want to reassure you, even Islamic law scholars had a sense of the complexity of inheritance, and so they say al-fara'id nisf al-ilm, that is, the science of inheritance is half of science. So they have this perception of complexity. But I don't want to reveal more about my position in this case at this moment. So let me just introduce Samia Bano, our last speaker. She's senior lecturer at SOAS, University of London, and again, among her various publications who focus or center on Islamic law in the UK, I will just mention Muslim Women and Sharia Council, Transcending the Boundaries of Community and Law. Of course, the UK is a significant, has a different setup from the Greek case, but we're very much looking forward to hearing her remarks. So please join me in welcoming Samia. Whichever way you go.
Okay, thank you very much. Thank you very much, and thank you. I just want to kickstart off by with thanking the organisers for the invitation. I too know very little about this case, but I was asked to remark to the two very excellent presentations and papers, but also in relation to some of the work that I do with Muslims in Britain in relation to the practice of Muslim family law and Sharia councils. So I just wanted to start off with actually a little bit of what Marie said, also in relation to some of the key themes that were presented in the two presentations, because I think that what I'm going to do with my presentation, I haven't made anything formally, but what I want to do is to pick on some of the key themes that we can draw upon from the presentations and then think about them in a wider context in relation to the position of minority Muslim communities in Europe, but more specifically in relation to Britain where I work. So firstly, I wanted to draw attention a little bit to the socio-political context, and I think some of the points that you made in relation to the current right-wing narrative that we're living under at the moment, which seems to be going on across the world, is very important in relation to our understanding of the way in which the law operates. As we know from a lot of scholarship, feminist and critical legal scholarship, law isn't objective, neutral and equal, right? It doesn't necessarily come in taking in all these universal liberal values, but it actually takes shape in very particular ways in relation to the individuals and communities to which it applies. So I'm going to just draw upon some of the key themes that were addressed. But before I do so, I just wanted to give some background to my own research. I am a British Muslim, may have noticed some from me. I'm from Birmingham, and I work around the issue of Muslim women, British Muslim women, second, third generation Muslim women, and why they choose to resolve their matrimonial disputes in Sharia councils or religious tribunals. I'm sure you've all heard of these debates. The Daily Mail in particular likes to tell us that Muslims are going to take over the world every couple of weeks. So there's been a lot of debate and discussion around the role of Sharia councils and Sharia courts. Well, they're called courts, but they're not really courts. And the key question that I have been interested in, and I'm continuing to be interested in, I've just published a new book looking at mediation and arbitration, looks at the question of identity, positioning and community. And that is the question of why, if you have civil, secular law in relation to family law, would you go away and choose to resolve your disputes in religious bodies? So I'll come back to some of my findings around that research. But the first point I think I wanted to make in relation to the presentations was this question of heterogeneity. So I know we're speaking in this Greek context, a very specific community. But I think the first problem when we're thinking about this, and I also understand that some of these debates possibly can never be resolved, but we have to think about the heterogeneity of the communities that we're speaking about. And I think that's very, very important, because one of my concerns with a lot of political theory and legal theory around the debates of multiculturalism and minority rights and the work of, Kim Linker and others, is this idea that somehow communities are homogenous. Even though they talk about, oh, there's a heterogeneity, I think that's a pivotal and very important point, because I think power relations within communities are very, very important. And of course, in the human rights context, the rights of the individual are very important. But I think the way in which the individual operates and lives in their private and family lives is of fundamental importance. And I think over the past couple of decades, that work, that critical engagement has been lost, right? The liberal political theory that talks about minority rights and multiculturalism and respect, and obviously this is very important, and tolerance for communities also has to take into account power disparities and inequalities within those communities. Because if you don't, then the rights of the individual of being a minority within the minority gets lost. And I think that's a very important point, and often a point that gets lost, I think, in a lot of human rights literature, that we respect these communities, and it's important, obviously, and we have universal values of tolerance, of equality, of non-discrimination. But actually those spaces of critique, right, have been increasingly lost. And I also blame academia for this, because I think so much of academia doesn't speak to lived reality. And when academia does speak to lived reality, often it orientalizes the other, okay? So Muslim communities get framed both by very good liberals and by bad liberals, in the way that, you know, good liberals often say, well, this is what the community does, and this is how the community operates. What do I know about the community? I'm an outsider, so therefore I will just respect what is going on. Now, this has huge consequences for minorities within minorities, and we know, belonging to Muslim communities, that the issue of gender and gender equity and gender equality is important, you know, has also, you know, lots of liberal scholars do, but I think the very lived experience is one that we have to draw upon if we're going to challenge what is going on in practice. So that's, I think, a first point that I wanted to make, that whilst, you know, a lot of this work around, and I'm not necessarily speaking about the presenters, but a lot of good work by liberal scholars around human rights is very well-meaning, it actually doesn't ask those critical questions. And I think only by asking those critical questions are we going to move on with some of those debates. Secondly, what I wanted to say is that this very interesting case raises fundamental and important questions of what is the role of the law, right? So in the minority Muslim context of British Muslims, there's a lot of debate around Sharia councils with the argument that this is what Muslim women want. They want to go and resolve their matrimonial disputes in Sharia councils. When I've done my research, and there's been new research post my research, on this question, we have found actually that is a very nuanced finding. The whole issue of why Muslim women choose to resolve matrimonial disputes in these spaces is very complex, and often it is not because they want parallel legal systems. They do not want alternative bodies set up to resolve matrimonial disputes, because these communities are very new, right? And I also am now beginning to think that it's racist, actually, to argue that Muslim communities should be resolving their disputes in parallel legal systems, because actually as citizens we have the right to be protected by the state, right? And these communities are young, these communities don't have the capability, don't have the governance or the framework to be able to resolve very, very complex, problematic issues. So to argue this is something based upon rights, I think is hugely problematic. And I think we have to take that into account, because for me, the role of the state, you know, and the state isn't objective and it's neutral, and it often doesn't work in my best interest, but it has a very important function of protection. And that function of protection and protecting the most vulnerable, I think, is an important point that we need to take into account. Secondly, the question of community, right? What is the Muslim community? Who is this community? And what should be the role of the Muslim community in relation to Sharia and moving debates forward? Now, what we know from the British Muslim context is that migration happened in a politicized context. Okay, there was a reason certain groups came over at a certain particular time. There is a reason today why certain groups from certain countries, or actually nobody with a hostile environment, comes in today, right? So the socio-political context of who these communities are and the socio-economic context in which these communities live are very important. Most Muslims today live in hugely challenging socio-economic contexts and communities. The two largest groups, the Pakistanis and Bangladeshis, have huge problems around poverty, access to education and employment. And so I think that these questions have to be fed into wider debates around identity, because the research on South Asian Muslims in Britain suggests to me and other scholars is that actually most Muslims, South Asian British Muslims, will say they're not really bothered about Sharia law, right? What they want is good jobs, housing, employment, and education. So this idea that somehow Sharia and identity of Muslim identity should be framed around Sharia, I think is hugely problematic. And again, we have to think about where this is being driven and how this is being driven. So I think that's an important point to bear in mind. Secondly, or thirdly, going through my points, Muslim women. Okay, so I think, again, coming back to the question of gender, I think the point of listening to the voices of Muslim women is of fundamental importance around debates of Sharia. Whilst I think representation is important, we know that representation doesn't necessarily lead to change, but of course gender representation is important. What my research and newer research also points to is that Muslim women are very critical of parallel legal systems. And I can, in the question and answer, I can go into why they may choose to resolve their disputes in Sharia councils, but actually Sharia councils can be a representative or symptomatic, of their experiences of having very little voice, authority and autonomy within the private space. Now, this isn't then to argue that Muslim women fall into the dichotomy of either, you're subordinate and oppressed, or you're Western and you're enlightened. But what the existing ethnographic research demonstrates is that Muslim women are very strategic and are very sophisticated in how they use religious tribunals, but it's not in the way in which you're advocating parallel legal systems, because unfortunately the existing legal system is racist and sexist and classist and whatever we want to describe it as. So if you then argue that communities who have huge problems in terms of access to resources and issues around capability can somehow transfer or take over issues of family law, very complex family law issues, I think is a dangerous precedent and something that we have to be very, very cautious about. And that's where the voice of Muslim women becomes very, very important. Also, I wanted to just raise the question of comparing Muslim and non-Muslim states. There is a lot of change going on in the Muslim world, and one of the positive changes in the Muslim world in places like Tunisia and other places is where there's a reform of Muslim family law codes and polygamy is being abolished or severely restricted. And I think it's important to look to the Muslim world, that the point has been made. But I think it's also important to look, it's difficult to transplant those changes into minority Muslim contexts, because I think the socio-political context in which minorities operate is fundamentally different. And I think that's an important point that we also have to bear in mind. I'm also not convinced, maybe I'm becoming old and cynical, of the rights-based approach, right? The human rights and the rights-based approach, because I don't think the human rights approach has necessarily been able to capture those questions of complexity, power and inequality. And as I've said, I'm very concerned about liberal political theory and the move from individual rights to community rights, and this is something that we have to do in the name of respect and tolerance as outsiders. I think if we speak to insiders and actually have more scholars from the inside too, potentially, okay, that raises a different debate of inside or outsider, that can lead to more insightful debates in terms of how we capture these very important contributions around voice and authority. Then I just wanted to briefly just mention those questions that were raised around exit and exit options. There's been lots of interesting work, as we all know, by scholars such as Ayala Shajar and others, and Wilkin Linker and others on exit options. The only point I would make about exit options, and this is a point about discrimination and Islamophobia, is that the outside isn't necessarily a welcoming space, right? Which means that my options to exit aren't necessarily open, free or neutral if I have nowhere to go, right? And an option of exit is only one that I can exercise, or one can exercise if there are resources on the outside. Now, what we know in the British context, the resources of supporting BME communities, minority communities, and supporting those who are fleeing potentially problematic family law contexts has been hugely and severely restricted, right, through cuts to legal aid and closing down of refugees. So actually that option of exit, again, I think is theoretical. I think in practice it's hugely problematic in terms of how we can operate. Thank you very much. And in relation, sorry, just one couple of points. I have 2 minutes. Points about reform and having female muftis. Again, I think this is important, and I think it's something that Sharia councils have done in Britain. Very briefly, I didn't tell you what Sharia councils do, but I'm sure you all know they resolve matrimonial disputes for Muslim communities in a number of different ways. But it's hugely limited. I think the point was made that in Islamic jurisprudence there is nothing to stop Muslim women being muftis and being scholars. No, but there are plenty of Muslim men that can stop, right, Muslim women doing that, because reality is that jurisprudence and theory does not operate out there, right? It's in practice, and lived reality is very different to what our rights in Islamic jurisprudence and Muslim jurisprudence. And just the work, if we can just draw upon the work of Muslim feminists, Muslim feminist scholarship shows the backlash that these scholars get, right? So when you're just looking at the question of reform and reform in Sharia, and the good work that's been done in Morocco and Tunisia and Malaysia, the backlash that so many Muslim women have to experience is often at a huge personal cost. So I think those debates around option of exit is also one that we have to bear in mind. And I would argue then, very quickly in conclusion, that yes, the state is flawed, state law is flawed, but it's an important mechanism for protection. And we should be strengthening the rights for Muslim women within this existing legal system rather than within the wider context of parallel legal system in the name of tolerance and rights. Thank you.
Well, thank you. I will just open the floor now, but I will give you a couple of minutes to think about the question. Oh, you already have? Okay. So let me just say that, just to bring it back somehow on the specific case, the reason why I think it's particularly interesting to look at this issue of inheritance is not just because of the complexity of the regulations and also the way it touches our, fundamental existential decisions and positions. It's also because it touches at 2 critical areas of socioeconomic, so the transfer of property, so inheritance is one of the major ways in which property and especially real estate is transferred, and the gender dimension to that. So the fact that civil law or state law, especially in the Balkans, has actually been used to somehow privilege male heirs over female heirs, and then so to disguise that by saying, hey, you know what, heirs at the same level, the female gets half the share of the male, is somehow used to actually prevent female heirs from getting that half share. So the end result is that the female heirs get the 0 share. So these dimensions of gender and socioeconomic development, socioeconomic structures that inheritance underpins is what makes, I think, this case particularly interesting. And the other aspect that I think it makes it particularly interesting is that the solution is very difficult, because the law that was put forward by the Greek government somehow solves the issue in the easy case, which is the case of matrimonial disputes. And so you request both parties to subscribe to the jurisdiction of the Mufti. But in the case of inheritance, who do you ask that? So the answer is the propositus, right? But of course the propositus has a preference, and what we see here in the case is that what the parties that are playing it are the widow and the sisters. And so, I mean, if you put, if you always put the propositus in the position to choose, then you will of course have one result. So inheritance is very tricky for, I think, at least these three levels. So who has already a question? 1, 2, 3. Okay, that's 4. Please.
There's so much going on in my head right now. I don't know where to start. But starting with what the two of you said, okay, I know the men get a good beating from everything, okay, where women are concerned. But we have to take into consideration, especially I'm a trustee and I do a lot of counseling with women who have suffered domestic abuse and violence, okay? It's just not always the men. It's the family they come from. Yeah. It's the extended family that put pressure on these women that they dare not come to the legal. They would love to, but they don't. So they submit and give in because they have sisters. Who will marry my sister is a question because it's all a community. So I say to you, it's more complicated. And when I listen to the stories the women come with and how their hands are tied, they can't just leave. I have helped a lot of women and said, yes, I will help you, and you just come to me and I'll take you to a place where you'll be safe. But you're right, it's becoming less and less.
Yeah. Can I just say I'm not really anti-men?
No.
Actually, maybe I am. No, but no, I absolutely agree because the point was about family and community relations and the power inequities. There are some women who have power in the family, right? And I also I was a domestic violence caseworker, and you're absolutely right. The women used to come and say to us, there's nothing wrong with my husband, it's my mother-in-law. That's the first thing. She's causing the problems, right? So there's a lot of complexity in there, but the question is that how are these religious and cultural codes, how are they upheld?
But I had a Pathan woman, okay, and I did individual counseling with her, and she said, I don't know where to turn. My sons tell me, why do you take it? Okay, and her sons, grown-up sons are telling her, why do you take it? So one day, through empowering her, she one day stood up to her husband. And he said, what's happened to you? You seem to be changing. And she said, now I know what I have to do. Get out. I'm not leaving this house. You go. And what she did was, she went to social services. They took on the case. And she's independent. She's got what she had. And her children are with her, 2 daughters. Because the father wanted to take the daughter back to Pakistan to get married to some cousin.
I hope the story did not end up with an inheritance case.
You can empower women. You can empower women, but it's the extended family you have to also take into consideration.
Thank you. I have one question, please. Yeah, I have.
May I ask 2 questions?
Yes, if they're very quick.
Yeah, very quick. Okay, first question is for Samia. I think Samia.
Yeah.
It's okay. So whether or not the plaintiff Sally wins the case in the European court, the matter remains. The consequences of this verdict will come to the UK. You cannot avoid that. And especially in the cases where there is a khula and the weddings are not registered, UK weddings are not registered in civil court. So what happens is that those women don't have any other option in the case of khula than just to go to Sharia courts. So they are actually stuck in Sharia courts, and when a man decides not to divorce his wife, then women's rights are actually compromised. So do you think that after the Brexit, there will be some consequences for this whole situation to change? And the second question is for Yüksel, Dr. Yüksel. You mentioned about Thrace, that Thrace has these Mufti codes. I'm just wondering, and if you look at the literature, then it very clearly shows that Thrace has a Sunni population, majority are Sunni. I'm just wondering if there are Shia population as well, and if there are some Shias, what happens to them? Do they go to the same muftis, or they have different system? Thank you.
I already have 3 questions lined up, so I'll take these 3 and then give the floor to the in front of
The Soli case seems to be driven by a fascist golden dawn, it looks like, because they have been pressurizing for the change of the law and special dispensation for Muslims of Thrace, it looks like. I personally feel there is a great dichotomy, a sort of a mind of a devout Muslim will feel that the word of God is not obeyed, you see, and the Muslims feel, as you were saying, about their things are not respected, you see, that there is undercutting of the Islamic law side, which I am not sure. And the question of I've read about the Sharia council in where the judges or qadis are not qualified and not very erudite as such. Can you comment on these 2 points?
Please.
Saudi Arabia is sitting on the United Nations Human Rights Commission and Women Commission with the backing of the UK. And I wonder if this has any implications on lowering the standards of human rights and that Sharia is making more inroads in Europe.
Thank you. So I have one last question here.
Okay, just my question will be for Professor Tsitselikis. It's about the direct appeal to Mufti decisions, and I am wondering whether the establishment of the Mufti in Athens can be one of the way to sort out these appeal issues. And also I would like to add a small comment. When we say Mufti tribunals, there is not tribunals as far as I know. It's only one person, and he decides how he wants, basically, and are not qualified, are just regular local imams. And about the reforms, and there is no dialogue actually to carry out any reforms in Western Thrace, and the decision makers do what they want.
All right, so then I'll turn it back to the panel. Few minutes each. I would go back in the order in which we heard the presentation. I think you can, if you want to come to the lectern, or if you want to speak here in the microphone.
The reverse or the...
No, the original.
The original.
Yeah. You want to come here? Okay.
So
this one is actually working. In case you
can I have 1 hour?
Yes, 1 hour. 1 hour?
Can he have
1 hour minus 62 minutes.
Very interesting. We have so many things to discuss. So the one important thing out of this Greek case is that the implication will cover the whole continent. So that's why I agree with you. The first country to be affected would be the UK, that you have a visible tribunals. However, we have to take into consideration that Germany, France, Italy, and other countries have invisible. So when they will become visible, this is another big political issue, that Islam has to become visible. We will have this contact issue with the courts and the legal order. And this one, there's no answer to this, because you have to see the judgment. So the judgment now. And the case, because Marie Benedict opened some interesting cases. I would like to say that I didn't have the time, that there is a risk. There's a risk. The court and the judges are conservative. We know that. And what they want to, not to open the big issue of an Islamophobic judgment. This is a very big concern. That's why we try to formulate the questions and the answers to the questions addressed to us in a way not to open the huge compatibility between Sharia and human rights. on the contrary, to find the common grounds. Of course, there are violations, according to my opinion, as it was applied in Greece, but not to go further and not to start formulating general assessments about Sharia law, blah, blah, like they have done it 10 years ago in the Refa Party system. In the Refa Party system, they said, okay, this political party has a program to bring back Sharia. Sharia is not compatible. This violation of human rights. Okay, this was a...
But in that case, they were following the Turkish Constitutional Court, right? So they were picking up on their
Yes,
which is problematic on its own.
Yeah.
But this is the background in this case.
Yeah, absolutely. Yeah.
Because there's nothing between.
That's the precedent they will be looking at.
So there's no in between. So this would be the precedent in a specific case. Although we don't have a Mufti's decision to be checked. We have a court of cassation that said that Sharia should be obligatory. And this is the problem. The option is here. So this is about the risk, and I agree that, but on the other hand, we had to go further. We had to use the human rights as a tool or a mechanism to secure women's rights in that case within Islam. So that's why I see, okay, there are problems, but we have to see the other side, the bright side of the case. Another important thing is the change of Islam from within, and this is very important. So that's why there is a risk to say, okay, to cut, even the Greek government could do it. You're right, okay, there was no big discussion. We have to take into consideration that there's no discussion within the minority, and this is very problematic. And the women within the minority are silent. So there are no voices. So still we'll have a paternalistic frame to be imposed, but at least we can say all of us, and women from the minority, that, okay, is a step ahead for sure. And the tables you showed, I think they reflect the positive step. Of course, there's a power relation between states, among two states, and between some governments and the minority, and of course, power games and power relations within the minority. So we have different layers, and we often forget the class issue. The class issue is very important. It's of course different to talk about rich Muslims and poor Muslims because they're just, not because they are Muslims, because they are rich or poor. They have the right or the possibility to exit, and this is very important again. But we don't have to forget that exit is a mechanism to go out of this suffocating environment. So exit is a bit problematic as an idea, to where, how, who, to, but still is an open gate to go somewhere. Anyway, we're not talking about a total exit from everywhere. It's a sectorial exit from a law that was obligatory for the women in a negative perspective. So I think this small gate, again, is not the exit from the community. That women are not going to be stoned if they go to the civil court. I mean, you don't have to exaggerate a bit. I mean, of course, very complicated. It's very complicated, I see. The class issue, we don't talk a lot about, is the most important. If we have to take other nuances to shape the whole problem. Orientalistic, I think there is an internal Orientalism in Greece
within the community.
But here, this is something strange. In a normal paternalistic, Orientalistic way, the Greek state would have abolished Sharia in a normal political framework. Here we have the opposite, keeping Sharia for an enclosed community. So this is the important thing in that case, I think. So inheritance, and then I come back to you, Gianluca. You asked me this question 3 months ago. So Gianluca asked, what happened to this properties inherited if the grandfather who had died 20 years ago, who created the properties and left them only to the son. And now the sisters come and ask for the share according to the ethics of a humane society to share the properties. It wasn't the case. So the grandfather died and the properties were distributed according to the civil code. So the sisters have acquired already their share according to the civil law. So I think in that case, the fact that they claim Sharia law just to take some properties was not very complying with ethics. In the other case, I would agree with you that, okay, Sharia law would play, again, the balancing way. The properties would be distributed equally, but not in that case.
But litigants are always strategic, right?
Okay. So,
especially in inheritance cases.
Yeah. So Gordon Dawn, I mean, the fascists in Greece, of course they would like to abolish Sharia, and they have said it in the parliament. But, okay, I'm not in favor of abolishing Sharia, and we try to do it in a way to trigger from inside a reform. This is the point. Of course, many people would like to have abolishing Sharia at once, but it is not the case.
So Yüksel, you can either use this microphone or go to the lectern as you go.
Let me go.
Microphone.
Because now the Greek guy has spoken up.
There's actually for your privacy, did not disclose that there's a Constantinople versus Thessaloniki dynamic, Greeks, Turks. It's very complex, yeah.
So what I'm going to do, I will make very brief 3 points, because I want everyone in this room to understand the following. I think it's great that we juxtapose Greek case through British case as well as it allows us to think in comparative terms and brainstorm. But let's understand this very clearly. The Mufti system that we talk about, they are formally integrated into the Greek legal system. Muftis by Greek law are state judges, and their decisions are enforced by the Greek police, by the Greek state. So this is very important. We're not talking about arbitration councils or tribunals, which are informal, on the ground, or parallel, however you want to define it. So this is very important. And also, as I don't know if you're aware of, I keep saying Muslim family law rather than I could just opt for a short term Sharia. I don't like Sharia because it's really a wrong term to be using. Both on the right and left, everybody is using Sharia for certain ideological, political, normative reasons. I think it's better to keep it away, but rather call it Muslim family laws as a plural term. We have to understand they're multivocal. And the point that I'm trying to make, I'm not again here in favor of abolishing Mufti system or Sharia. I don't think it's my place as an impartial, independent scholar. What I'm trying to say rather, we're talking about a democratic European society, part of European human rights system, where there are some sort of Sharia or Mufti courts as integral part of the state system. So here you have to give people the option to choose. Yes, exit option is always problematic, but at the same time, in a democratic free society, you cannot impose Sharia upon people. In this Greek case, the Greek Muslim in question said, I do not want Sharia. In fact, if you go to Santi Comotini, you will see 99% of the Muslims do opt for civil will. They would like to distribute their estate equally between their sons and daughters, not the other way around. But the Greek state, democratic secular republic, comes and says, no, you are a Muslim, you have to be subject to Sharia. So this is the case that we are concerned with here. So in that regard, exit option is important. But as I said before, for exit option to really work properly, you have to raise the awareness of the option among the community, Muslim, lower class people, etc. You have to provide pro bono translation. You have to make state courts more accessible. You have to set up new clinics run by the minority NGOs in the region. So they are the minimum standards for the exit option to work. But whether we like it or not, in a democratic society, you cannot mandatorily impose any religion-based laws upon people without their clear consent. Thank you very much.
Thank you. Thank you very much. Okay,
Again,
so,
for you, if you want to do it here, as you want.
Oh,
It is on.
Oh, yes.
Yeah.
so just thank you for those answers, and also just quickly for the two questions. So firstly, in relation to post-Brexit, I don't think any one of us know what's going to happen post-Brexit because the government doesn't know what it's doing. So we shall wait and see. But in relation to Sharia councils, you're absolutely right. Today they are not, those individuals who don't register their marriages are considered cohabitees. The question of whether this then compels those individuals to use Sharia councils, yes, to resolve their religious divorce, but no, if they want to distribute assets. Okay, so financial provisions part of the family law system is not and cannot be taken over by any Sharia council. That maintains, has to be maintained by the jurisdiction of the English family courts. Okay, so, but yes, there is a question of Muslim women having to then go if the husband refuses to pronounce the unilateral talaq. So under cohabitees, there's a whole framework where rights are afforded. It's problematic, but you do get some rights in relation to the individual. For children, the family law courts come in. You know, we think we own our children, as we know we don't. The state has a responsibility for welfare and protection, and the state will come in and do that. So I don't know whether that's asked your question. Very quickly, in relation to unregistered marriages, what Muslim women's groups are arguing for is an education system or program to educate Muslim women to register their marriages, not to have more Sharia councils. Okay, so that I think is an important point. In terms of who the Sharia council judges are, well, they are often professional or lay people from the community. And I think there is a huge problem, because one thing that we do know with minority Muslim communities in Britain is that there's power games that go on. These communities are often competing against each other for resources. So there are some Sharia councils that will only speak to Bangladeshis, Pakistanis, others that are set up for Somalian communities, others that are set up for all Muslims. So there's a whole diversity going on here. And I think, you know, with all due respect, I think Muslim family law is very complex. And I think the idea of these people being able to take on these roles is hugely problematic. What I would say, the point that Yüksel made was very important in terms of, you know, these are unofficial bodies. Now, the argument that somehow they want to become official, I think is false and misleading. Most Sharia councils don't want any state regulation. They don't want to become like Greece, right? Because they don't want that level of scrutiny, firstly. And secondly, it doesn't become Islamic Muslim family law if it's a secular lens to them. So they argue they want to keep it private outside of state law. So there's not an automatic move towards wanting these bodies to be regulated. But I think there are huge problems in terms of who is delivering the verdicts and how these verdicts are being delivered. And also another point is that the role of solicitors at these bodies is hugely dangerous, because so many solicitors that I know come in and start negotiating. Okay, my client will do this if, you know, so-and-so can see this, and what is Sharia law, you know. So there's a whole complexity that's going on the ground that I think is really quite difficult. But we, you know, we've just had a Sharia review by the Home Office that was led by Professor Molla Sali, and I was involved a little bit at the start of it. But that then found also that, you know, Sharia councils, firstly, they shouldn't be regulated. Secondly, Muslim women don't want regulation. And thirdly, there are huge dangers of moving these very problematic and complex debates from the public to the private. Because in English family law today, that's precisely what's going on through mediation, right? So all family law cases now have to be mediated before you use the adversarial legal framework, and that is hugely problematic because the state is abrogating its responsibility to very complex issues. And these communities, at best, are very young and inexperienced. right? You know, we're talking about 50 or 60 years, and suddenly, under the framework of multiculturalism and human rights, we should be allowing these communities to deliver this level of justice when over hundreds and hundreds of years, the English legal system hasn't got it right. So I think actually the argument is that you're denying justice and equality and citizenship. And I think what Yüksel just said actually is a very important point that we should be very careful about, because that's the end result. The end result for me is being told that I have to go to these bodies because I am a Muslim, right? And the state should never have that say, right? And I think that's the danger. So if these debates are having an impact in other jurisdictions, those are the dangers that we have to bear in mind.
So I'm very happy, because if we had our Brexit question, then we're a successful event. However, I think I should reassure you, but here the authority is to my left, that the European Court of Human Rights is not connected to the European Union. So as long as the UK will be a signatory to the European Convention of Human Rights, then the jurisdiction of Strasbourg, whether you like it or not, but we always need to be critical about it. And
yeah, I would just say we always want to push the European Court of Human Rights to be more progressive than what it already is. But obviously we don't want to abolish it.
So hopefully whatever happens on March the 29th of 2019 will not affect the participation of the UK into this system. So nothing is left but to thank you for coming. I hope that we have raised a few issues that will probably help you read the ruling when it will be announced and come out. So if you're interested in this sort of activities, please make sure that you are involved or that you have signed up to the mailing list of the governance program, because this was organized under its aegis. And so the last thing that remains is to ask you to join me in thanking all the panelists.